So hello, good morning everybody, and welcome to today's webinar, which is on the new permitted development rights, rather jazzily titled "The Only Way Is Up." If I had a better singing voice, I'd obviously sing you some of that classic 1980s hit, but don't worry, that's not going to happen. I'm just going to, my name is Suzanne Darcy. I'm a Senior Planning Officer at South Gloucestershire Council. I was the Chair of the RTPI Southwest in 2018, so some of you have probably seen me with slightly madder hair colours standing at the front. Slightly weird to just feel like I'm talking to myself this morning, so I'm not going to talk for very long, you'll all be pleased to hear. You will notice, some of you may have booked some time ago, we have had a change of speaker. It was supposed to be Graham Grover speaking to us today, but unfortunately Graham is not very well. So we've had Hannah Mannion and Christian Hawley step into the breach for us. I'll introduce them just before we get to their presentations. A couple of points of housekeeping before we started. You've all been muted because there's quite a lot of people on the webinar. If you've got any questions, if you can type them into the question panel that you should appear on your screen. I can see them, and Charlotte can also see them. So what we'll do is we'll ask a selection of them at the end, and any that aren't answered, we'll try and the speakers will try and answer them through sort of a follow-up email that will come after the presentation. If you've got any technical questions about kind of how the webinar works, what happens next, timings and so on, ask them in there as well, and Charlotte from RTPI Southwest will deal with those for you. So you will have a copy of the presentations. They will be able to be downloaded from towards the end of the session. If you lose connection, just please try rejoining from the link that you were sent originally in the webinar. Hopefully you should be able to come back to us. If one of our speakers loses connection, if you can wait in the webinar and keep an eye on your emails, and we may have to relaunch with a new link which will all be sent, or if not, we might be able to just sort of reconnect through this. So to start us off this morning, we have Hannah Mannion. She's a solicitor in the Planning and Compulsory Purchase team from Burges Salmon. And Hannah is going to kick us off this morning. Hannah.
Thanks, Suzanne. If we could just change the slide. Thank you. So whilst we have all seen and no doubt experienced in different ways a number of changes to everyday life, which have taken place in the world in the last 6 months or so, I'm sure you're all aware that there's been much change to the planning system during this time. With the world looking slightly different to how it was this time last year, the planning system in England has also had to learn to adapt. I'm sure you all agree that it's sometimes hard to keep up on everything that has been happening since March of this year, where we have seen many changes to the planning system, such as the introduction of a number of temporary permitted development rights and regulations, measures to ease the planning system, the introduction of a new business and planning bill, and what feels like the new norm, that is virtual planning inquiries, just to name a few. It's clear that flexibility within the planning system, which is often thought of as being too prescriptive and rigid, has now become increasingly more important. As most of you will have seen, as part of the government's attempt to boost the economy following the coronavirus pandemic, they have pledged to radically reform the planning system, with Boris Johnson announcing famously back in June 2020 that there would be a new package of measures to build thousands of new homes as part of the government's COVID-19 recovery plan, and said the measures would include the most radical reforms to our planning system since the Second World War. In August, the government published the long-awaited Planning for the Future white paper, which set out a number of measures the government proposed to introduce to get the economy going again. As part of these plans to reform the planning system, a number of changes to permitted development rights have been introduced, which I will discuss in more detail shortly. It's also worth highlighting that these changes relate to permitted development rights in England and therefore don't apply in Wales or Scotland, where other regimes exist. Next slide, please. So what is permitted development? I'm sure you all know that under the Town and Country Planning Act 1990, planning permission is required for the carrying out on land of any development under section 57(1) of the 1990 Act. Development is defined as the carrying out of building, engineering, mining or other operations in, over or under land, or the making of any material change in the use of any buildings or other land. A change of use of land or buildings generally requires planning permission if it constitutes a material change of use. However, permitted development rights allow, subject to some exceptions, certain changes of use without the need to apply for planning permission. The Town and Country Planning Use Classes Order, which I will refer to as the Use Classes Order, specifies certain classes, which we refer to as use classes, and they provide that a change of use of a building or other land does not require planning permission if the new use and the former use are both within the same specified class, i.e. it is permitted development. The Town and Country Planning General Permitted Development England Order 2015, which I will refer to as the GPDO, allows for these specified changes of use between the use classes. Permitted development rights are generally subject to conditions and prior approval requirements and can be subject to certain limitations. For example, I'm sure you're aware of Article 4 directions, which may be in place, which remove permitted development rights in a specified area. In previous years, there have been a number of amendments to the GPDO, which has allowed a number of specified changes to uses between use classes. For example, you'll all be aware of Class O, which is office to resi, and Class Q, which is agricultural to resi. But the GPDO has often been seen to be outdated, does not allow for flexibility, so I'm sure the new changes will be welcomed. So, a wide range of changes have recently been made to the permitted development regime, as I mentioned. These changes have been implemented in a piecemeal approach through different legislation, and they largely support the government's plans to radically reform the planning system. They have also formed part of the government's response to changing circumstances arising from COVID-19. Last week, on the 1st of September 2020, the Town and Country Planning Use Classes Amendment Regulations 2020 came into force. These make a number of amendments to the Use Classes Order, which I've just mentioned, and the Use Classes Order, as I said, refers to certain use classes. The changes will enable many more changes of use to be made without the need for planning permission, and specifically supports more flexible uses of premises. So these changes include, there's the introduction now of the new Class E. This is the most significant change, and this relates to commercial business and service uses. Sorry, can you go back to my, sorry, the slides have gone a bit. Yeah, thank you. So back to Class E, that's the most significant change, and that relates to commercial business and service uses. This will cover buildings, including shops over 280 metres squared, offices, restaurants, cafes, research or light industrial facilities, health centres, nurseries, gyms, or indoor sports centres. So those will now fall within the new overarching Class E, which is a very wide, will contain a very wide use. This means changes between these types of uses will now not need planning permission. This flexibility is welcomed by landlords, who can now take advantage of the market forces that shape what premises can offer. Although it is important to note that leases may need to be reviewed to ensure that they are fit for purpose, and this is something that will need to be kept in mind if you are hoping to benefit from the new Use Class E. The government is also hoping that the increased flexibility will help high streets and town centres to adapt quickly to what consumers and businesses need. Whilst local authorities are likely to have concerns that their ability to achieve a desired mix of uses will be reduced, it's worth noting that the changes are not just limited to the high street, as many may first perceive, and will also apply to out-of-town proposals. There's two novel use classes which have also been introduced, which is F1 and F2. The new use class F1 covers learning and non-residential institutions, so anything that's not including residential use, such as schools, art galleries, museums, libraries, they will now fall under F1. F2 is local community uses, and this includes small shops which are not more than 280 metres squared, because that will fall within Class E if they are more than 280 metres squared. Community halls or meeting places, swimming pools, skating rinks. Changes within the new use classes F1 and F2 will not need planning permission for changes between them. So you can go from F1 to F2 or F2 to F1. There's a number of uses which will now fall within the sui generis use. This will allow local planning authorities to continue to be able to exert influence over pubs, wine bars, takeaways, cinemas, concert venues, etc. So they will now join the list of sui generis uses, i.e. that they will be in a class of their own. Generally, sui generis uses cannot be changed to any other use, including any other sui generis use, without planning permission. So this will allow the local authorities to have a bit more control over those use classes. It's really important to note that there will be a material transitional period from the 1st of September 2020 to the 31st of July 2021, where references to uses and use classes in the GPDO, i.e. the GPDO before the 1st of September, will remain as currently defined. So, for example, any references to A1 use, which is shops, will remain rather than being referred to as use class E, just to confuse us all. References to the schedule of the order in the context of prior approval applications or Article 4 directions made by a local authority to remove permitted development rights are similarly to be read in terms of the old use classes. So it's really important that when you're looking at new planning applications, you look at whether it falls within use class E, for example, or use class A1. This means that the changes will not become live in that context until the 1st of August 2021, and care will need to be taken to ensure it's clear where they do apply before that date. This will allow a period of grace of development currently permitted under the GDPO to happen with reference to the current use class definitions. Finally, it's really important to note that all use changes will still be subject to existing planning conditions and obligations, as well as to the terms of restricted covenants and leases, as can sometimes be overlooked where external building alterations are needed in order to convert a proposed new use. Separate planning permission will also need to be obtained. So this is also something that needs to be kept in mind. Next slide. Sorry, can I have the next slide, please? Thank you. The government also introduced an amendment to the GPDO on the 20th of July 2020, and these changes came into force last week, but on the 31st of August. So there's the new class use ZA. This allows for the demolition of a single detached building in existence on the 12th of March 2020 that was used either for a use falling within use class B1, which includes blocks of flats, offices, research and development, and industrial or any combination of them, or as a freestanding purpose-built block of flats, and its replacement with a detached block of flats or a single detached dwelling house within the footprint of the old building. So Class ZA is subject to a very long list of conditions relating to the old and new buildings, including that it does not apply if the footprint of the original building exceeds 1,000 metres, has been vacant for 6 months, or if the height of the new building would exceed 7 metres or 2 stories above the original building or 18 metres above ground. Whilst developers will not need planning permission, obviously subject to certain limitations, it is important to note that comprehensive prior approval is required. This now includes design considerations, ensuring adequate natural light to habitable rooms, landscaping, and the amenity of residents, including overlooking, privacy and light. This list has been expanded from the previous matters considered in the prior approval process to address concerns raised about the potential poor standard of homes created under the new PD rights. I know there's been a lot of commentary recently regarding the focus on housing numbers and the focus on just building houses and build, rather than actually the focus on having good quality design. So a lot of the changes do appear to be taking this into consideration and do focus on good quality design. A report for the management and construction of the development must also be provided to the local planning authority before beginning the development. This must include the method of demolition, proposed hours of operation and how any adverse impact of noise, dust, vibration and traffic is to be mitigated. It's also important to note that the right does not allow for demolition without subsequent construction of a new residential building or for the construction of a new residential building on previously cleared land. The demolition of the old building and its replacement build must also be completed within 3 years of the date of grant of prior approval. It's interesting if you compare the scope of this new permitted development right with Class O, which allows the change of use from an office to residential use, but does not allow any operational works to take place, meaning that those seeking prior approval tend to submit a follow-up planning application for works. The result is that the list of conditions and prior approval matters is much shorter for Class O. This has led to criticism about the quality of converted offices, and so the aim of the new Class ZA appears to have been drafted with that in mind. These changes will give owners greater flexibility within planning as to the use or uses of their property. We anticipate, particularly given the current circumstances in light of COVID, that owners of office blocks will be appraising options for redevelopment, both in considering Class ZA redevelopment in comparison to Class O, and diversifying under Class E in 2021. In cases where planning permission is still needed, it is likely that these changes will be relied on in demonstrating the fallback position of what could be developed if a slightly different scheme is proposed. Next slide. Thanks. In late June, the government published another new PD right, allowing for upwards extensions to existing blocks of flats under the Town and Country Planning coronavirus regulations. The government later extended this by allowing upward extensions to individual homes to allow for the creation of new homes or additional living space. This also came into effect last week on the 31st of August. So this covers 4 new classes of PD rights. You've got Class AA Part 1, AA Part 20, AB Part 20, AC Part 20, and AD Part 20. Sorry, that's 5 new. Enlargement, and this allows for the enlargement of dwelling houses by construction of additional stories, which is 2 stories may be added if the existing building is 2 or more stories tall, or 1 additional story where the building consists of 1 story. Story is defined to exclude any story below ground level and any living space within the roof of the dwelling house. And new dwelling houses are to be built on both new houses which are to be built on both detached houses and on terrace buildings currently either in commercial or mixed use or in use as a dwelling house. As with all PD rights, they're subject to a number of limitations and conditions, including that the existing building must have been constructed after the 1st of July 1948 and before the 5th of March 2018. The additional dwelling houses must be flats and the additional stories must be constructed on the principal part of the building. As with existing PD rights, the developer must apply for the local planning authority's prior approval of certain aspects of the proposed development. These include the impact of the amenity of any adjoining premises, the external appearance, and architectural design. A report detailing the management of the construction must also be provided to the council. So that's a very short whistle-stop tour of all of the new permitted development rights that have been introduced in the last couple of weeks. I appreciate there's so much going on at the moment. It's all quite technical. The government have promised some guidance, but this hasn't yet been published and they haven't given a date for it to be published. But because there's so much going on, it's really hard to keep up. So if there's anything, any questions or anyone has and wants to ask me after, then my contact details are at the end of this. But now over to Christian.
Kev.
There we go. I failed at the first hurdle to unmute my microphone. Thank you, Hannah. And good morning, everybody. Yes, I think just to draw through on that, as Hannah says, I think she put it as they are quite technical and permitted development rights are quite technical. And thank you, Hannah, for going through in detail those new permitted development rights, which are of course now in force. What I wanted to do, rather than continue going through the various permutations of what one can and can't do is focus really on what the reasoning for these new the expansion of these rights is, and the practical application of them and how they're going to affect both developers, local planning authorities, and of course third parties, the communities who will be hosting this development. So if I could have the next slide, please, Charlotte. I think you'll probably get it in a moment. So yes, the general thrust of the new permitted development rights, as Hannah said, build, build, build. I think it's also been known as project speed. And I think there is perhaps some debate as to whether speed and good planning necessarily go hand in hand. But what they do is build upon the move that was already in play in terms of restricting or expanding the ability to undertake development without the restrictions of full planning permission being required. And what this really does is, well, I suppose the headline grabbing feature is the expansion of what's generically known as office to resi. And there's been various examples of both good and bad office to residential conversions. But now, of course, there's going to be a much larger scope for development, which doesn't fall within the remit of a full planning application and won't require a full planning application. Much has also been made of, obviously, the impact of COVID-19 and the radical change to the planning system, of which this represents part. But I think when one looks at the last few years, this is, I mean, perhaps it's more radical or wider in its application, but ideologically, it doesn't really represent anything different to that which was already in motion. What has happened, in my view, with COVID, obviously it's brought into sharp focus a number of particular aspects of the way that people work and the way that people play. There's already been a long-standing debate as to the future of the high street, and in particular the use classes order and the changes to it are addressed or seeking to address what those changes are anticipated to be. But what COVID has done is it's accelerated that process, of course, and now firstly, internet retailing was already on the up and up, and now significantly so, particularly in terms of, I suppose, supermarket shopping, but also in terms of fashion and general retail. There's been a big shift in the last 6-7 months, simply because of the nature of what we've all been going through, to internet shopping or an enhanced take-up of it. And it's difficult to see how that will fall back. In particular as well, of course, there's the impact then on the high street, and lots of retailers who are going to have surplus space. And what the purpose of this is, looking at it optimistically, is an opportunity to address and reinvent that high street. Obviously, with the expansion of the permitted development rights, that will very much be market-led, because it will be up to developers to choose and landlords to choose what they want to do with their particular buildings. And the controls of local authorities have been slackened off somewhat. So the traditional approach of protecting solely A1 to maintain frontage, or, for example, restriction on hot food takeaways, though of course they go into their own use now. But those kinds of policies, which exist in a great many development plan, are now potentially in conflict with these expanded permitted development rights. The other important feature, of course, is the very nature of what we're doing now. I would have been surprised if we would have had nearly 400 people attending, or I think it's over 400 people attending a webinar 12 months ago, but now it's that much coined phrase, the new normal. And it's difficult to see how, for many people, they will be returning to the old 9 to 5, 8 to 6, 7 to 7, 5 days a week in office buildings in urban areas. No doubt people will return, but there will inevitably be a reduction in the requirement for office space. That will inevitably affect particularly the secondary and tertiary market. And also, because of the nature of leases themselves, whilst some effect will be felt in the short term, as leases come up for renewal, it is an effect which will be felt for many years to come. And in particular, the new permitted development rights, giving different options for redevelopment of such buildings, it is a way of addressing a market demand for residential dwellings, meets an obvious government target of boosting the supply of residential dwellings, but also gives flexibility to owners of office buildings which might well be falling out of favour for their original uses. If I can have the next slide, please, Charlotte. When that comes up, you will see that despite all the talk about these permitted development rights, and obviously your good selves are enjoying a webinar about it, many of you will be aware that there is actually a challenge against both the use classes order changes, the amendments, and the permitted development rights amendments brought by a group called Rights Community Action. Given the importance of the issues that are raised, because these are rights which will be affecting England, and they are rights which already affect England, that is a case which has been designated very quickly for a hearing between the 8th and 15th of October, so next month, due to be heard for 1.5 days. That, of course, might be the end of it, but of course, it could then go on to the Court of Appeal and potentially the Supreme Court. Those of you who have been involved in litigation will no doubt recognise that it's fairly unusual to be able to get into the High Court in such a short space of time. And what their challenge is against is both to amendments number 2 and number 3 to the GPDO and to the Use Classes Order amendment, and they raise 3 grounds. The important point to bear in mind is that those grounds are not against the substance of the rights or the substance of the statutory instruments themselves, but against the process under which the Secretary of State, the process that the Secretary of State went through to bring those into force. And essentially, they're divided into 3 grounds: a failure to carry out an environmental assessment for the purposes of the EU directive, fail to have regard to the public sector equality duty, and thirdly, which is then subdivided, a failure to consider both the consultation responses, so those responses which were made when these changes were first announced, and the failure to take those properly into account, a failure to consider the advice of its own experts, and that in particular is focused upon the findings of the Building Better Beautiful Commission in terms of the exercise of rights under Class O. And obviously we've all seen examples of development which has taken place under Class O, which has led to unsatisfactory outcomes. And people will have seen the reference to very small rooms without a window, creating what I think euphemistically called studio flats. Equally, I think it's important to bear in mind that one can always draw out bad examples. There are very good examples of how Class O has been used to deliver new dwellings in a pleasant environment, and ultimately to bring what was dated and potentially obsolete office stock into a new suitable use. And then lastly, that the Secretary of State adopted an unfair and/or irrational approach, and having undertaken consultation and allegedly not taken those consultation responses into consideration, then failed to reconsult, as it suggested that there was a legitimate consideration, a legitimate expectation that there would be reconsultation. If I can have the next slide, please. So that effectively is, in a nutshell, the case. Obviously, there's more to it. It's going to be heard for 1.5 days. Even if that challenge is successful, then by its nature, it's a judicial review. The decision is quashed, and the Secretary of State gets to reconsider his position. And my view is that the government appear to be wedded to these proposals. They do represent, as I've already said, a continuation or evolution of the change that was already in progress. And even if it's upheld, the Secretary of State can continue to progress the expansion of permitted development rights, but it may take a little longer, and perhaps the Secretary of State will need to be a little more careful in terms of how that is done. Equally, that could lead to another challenge, but that's the nature of any litigation. And if I could have the next slide, please. So turning to the permitted development rights themselves, then, really, what is the objective? It always was, or it's always been the view of this government and its predecessors before Mr. Johnson took office, that development is something which should be stimulated. In particular, the construction and property markets make up a significant proportion of GDP. And importantly, it's the nature of, I suppose, the housing market and the residential market in this country that it really does feed into how people feel about the economy, because so many people's fortunes are tied up with the housing market. A strong economy is synonymous with a strong housing market. People feel like they've got money to spend when the housing market is good. When it's under pressure, people generally tend to have a more negative view. And of course, macroeconomically, what we face now as a result of COVID-19 is a period of unknown. We've had the hit, as it were, where back in March, everything ground to a halt. And then through the power of technology and people's will to carry on, I'm sure many of you, whilst you've adapted your ways of working, have actually managed to carry on doing the job that you were doing just as effectively, perhaps in some cases even more so. But as we hopefully come through the pandemic, albeit obviously the news this morning is not looking ideal in terms of testing results, but as we come through that, the real economic impact will begin to bite. So there are a great many people who remain employed and have been supported by government schemes, and it remains to be seen whether the economy can be restarted effectively in order that what were historically low levels of unemployment can be returned. The construction and property market is particularly sensitive to the wider economy. It requires a lot of capital investment and it requires a lot of time. There's a lot of risk involved. So what the objective of some of these rights is to both stimulate that market, but make it more certain, make it easier to get the required permissions to deliver the development that people want to deliver, reduce the lead times for any permissions which might be required. That gives certainty, it reduces risk, it means that more companies and individuals are likely to engage in development. And in combination with the use classes order, is what it does do is it frees up towns and cities to, I suppose it's a fairly hackneyed phrase, to reinvent themselves and reconsider their role. What I think is important is that what the pandemic has done and what these rights are in part a response to is that it should give people pause for breath. There's been, many years of discussion about what the future of the high street is. This has been, an acceleration of that process. And what it should really do now is focus minds on, rather than necessarily trying to cling to the old. Not that I'm saying that the old was a bad thing, and there are a great many aspects of our high streets which we do want to support and continue, but more, I suppose, a case of the slow decline of some high streets is something which, is now being brought into even sharper focus. And there are the tools available where public and private sector can work hand in hand and work creatively to actually deliver a remodeling of those high streets, which of course then benefits all of the community that it serves. And then lastly, obviously, that golden objective of the government contribution toward housing delivery. It's about numbers. It's also about quality, but the focus that you see relentlessly is on numbers. And what I think, particularly those in the public sector, need to be careful of is how, what remains, what tools do they have available to them to ensure that, yes, housing is delivered, but also it's housing which is suitable in the long term, that it's housing which people can enjoy into the future, and that it's high quality development. And I have no doubt that many of you will have different views as to what these changes do in those terms. If I could have the next slide, please. So turning then to exactly that point, where does this leave local planning authorities, and in particular, public participation in planning? Because there's going to be a good many schemes that a good many people would have objected to, or would have wanted to raise concerns about specific issues which might be addressed through a planning application, might lead to amendments and changes which would deliver a better scheme. Where does it leave local planning authorities and third parties now that some very large schemes aren't going to be subject to the full formal planning process? Well, firstly, there is, of course, the requirement for prior approval, and Hannah kindly went through a number of the aspects of prior approval. But the really important takeaway point is that there is now a vastly expanded list of conditions and exceptions on these much wider permitted development rights, as there should be, because we're not talking about modest, the potential for modest schemes, albeit some schemes might be modest. It could be a single dwelling house, but equally it could be, multi-million-pound developments. And I think in the past, the prior approval process has been something, and I might be being a bit cynical here, something that's been regarded as junior to a full planning application, something that perhaps hasn't had the resource dedicated to it that it might. And I think it's really important now that these much larger schemes are available, that the appropriate resources are dedicated to dealing with those prior approval applications. Equally, the impact on third parties is that there's now a much more limited scope for objections. And I think from a political point of view, those third parties are going to consider themselves to be shut out of the process, because major planning applications can take months and months, some of them years, to make their way through the planning process, subject to various newspaper articles, focus groups, community meetings, etc. That doesn't apply if a prior approval. All that's required is a prior approval. So third parties who might wish to try and influence schemes are going to have to be very much more aware of the process, and they're going to have to be very quick in order to make sure that any concerns that they have are raised at an early stage. Otherwise, it will simply be too late. And if I could have the next slide, please. There are, however, a good number of caveats. Excuse me, that's my phone just coming through my computer. And in that, whilst it appears at first blush that there's all sorts of development that could occur here, new residential blocks built in our cities and towns, two-story extensions on the top of terraces in our towns and villages, it applies everywhere. Because of the nature, the wide range of those opportunities, because of that, there are a great many restrictions, and there'll be a great many proposals that simply, upon proper analysis, fall out of scope of permitted development rights. And that's a really important point, both for applicants and for local authorities, and indeed for third parties, that people really do need to get into the nitty-gritty of what these permitted development rights are and how they operate, because there'll be a great deal of debate, I suspect, over some of those conditions which pertain to the permitted development rights. And then if I can have the next slide, please. And that really is the devil in the detail. These permitted development rights aren't as open-ended as some journalists might have you believe. They do have a much greater range of restrictions than other PD rights. That's no surprise. But equally, despite those headline-grabbing schemes of large developments, in my view, there's actually an awful lot of opportunity here for good development to come forward in the form of relatively modest schemes. Everyone has in their mind the enormous office block, which is going to be demolished and replaced with an enormous block of flats. But of course, it drills down to being applicable to single dwellings as well. And there might well be a great deal of building stock out there which is obsolete and no longer fit for purpose. And actually, this does represent a good opportunity for the regeneration of such sites. But equally, there is the risk that development is not properly controlled and might lead to what could be termed bad or inappropriate development. And that again is why, in my view, really local authorities need to be mindful of what resource they need to dedicate to dealing with the prior approval application. And if I can have the next slide, please. Restrictions, some of them are very straightforward. Is the proposed development site in a conservation area? Is it in a triple SI? Is it near a defence installation or aerodrome? Those are yes, no answers. But I think what is slightly different in terms of some of the conditions and considerations for these permitted development rights is in the nature of the fact that they are, because they are much larger schemes, is that some of those conditions give rise to more planning discretion and actual consideration of the proposal, rather than what I might describe as a checklist approach of, if you manage to tick yes, I've satisfied all of the conditions, then I have, I can undertake the proposed development. An example of that in particular is in Class ZA, which of course is the big one. That's the one that allows demolition of potentially large buildings. I mean, Hannah raised the point about a footprint. It's limited to buildings with a footprint of less than 1,000 square meters, but of course, that footprint can still give rise to a large building. And one of the conditions, this is just one of a few which caught my eye, is this one on the slide, which is it's open to the planning authority to consider the impact on business and new residents of the development's introduction of or increase in residential use in the area in which the development is to take place. Now, that consideration is classically one of planning judgment. 2 points flow from that. Firstly, subject to reasonableness and rationality, it means that a local authority can consider, admittedly, in relation to this particular narrow point, the impact of the development, not simply whether it meets a permitted development right criteria, yes or no. Secondly, obviously, whilst there'd be the availability of appeal to an inspector, in terms of actually challenging that decision, that an authority acted on an unlawful basis, whether it permitted it or didn't, whether you're a third-party objector or whether you're the developer, that really is a matter that the courts won't venture into. They won't go into the realm of planning discretion. So when you get under the bonnet of some of these rights, that there are proper controls in there. I mean, obviously, whether there are sufficient number of proper controls will only know in time as these developments start to take place. But for example, in relation to the Part 20 permitted development rights, you can consider the impact on highways. Yes, a small number of flats may not have a particular impact on highways, but also parking. Now, it seems to me that a small number of flats in a place which has TROs already in existence or an issue with parking, that is going to be a thorny issue for applicants, and it does still give control to planning authorities in terms of ensuring that the development is fit for purpose. Also, because there's more of these conditions and some of them are wider, the application of them will inevitably be informed by future appeal decisions and future litigation. We only need to look at Class Q to see, that itself, a relatively straightforward, I'm sure many would disagree, but a relatively straightforward in comparison to Class ZA, for example, has given rise to a variety of cases as to what the meanings of those conditions actually are. And I anticipate that we will see a good deal more of that as these changes start to bed in and the prior approval applications start to be made. And if I could have the next slide, please. So in terms of those controls, just a thought really about planning committees as well. In some authorities, prior approval applications will go before planning committees, or certain ones may do, but generally, certainly on smaller schemes, they fall to be dealt with under delegated powers. I anticipate that particularly for high profile schemes, we will see such applications referred to planning committee. Now, obviously that's going to require some careful guidance, because in considering such an application, any committee would need to be mindful of that which they are allowed to consider and that which they're not, because it's a much more constrained process than a full application. And again, what we might well see coming out of some of those decisions is appeals and litigation. And the point, however, remains, I mean, it very much depends on what the applications are, but there's no reason in principle why development under these rights can't be very high quality. It can't, and in sustainable locations, and which achieves the objectives which underlie these proposals. But equally, it does require oversight and a close eye to ensure that poor schemes are rebuffed where possible. And if I could have the next slide, please. So in terms of outcomes, what I think this is going to lead to is it is going to require planning authorities to devote more resource to prior approval applications. Depends very much, of course, on the uptake. I anticipate in our larger cities, we will see good examples, or a great many examples of developers wanting to exercise these rights. Equally, in some other authorities, we might see very little at all. There's also, of course, many of you will be aware, in terms of Class O, a good many local authorities move to remove those permitted development rights under Article 4 directions, and it will be interesting to see what happens in relation to these permitted development rights. As well, just as with any permitted development, it could be the smallest extension on a domestic dwelling or conversion of an agricultural barn. Both local planning authorities and applicants really need to be careful of working their way through these provisions, because there isn't really any discretion if somebody gets it wrong, and there's plenty of tripwires and bear traps through the process, which could lead to the wheels coming off a development which has actually already started. Of course, I would say this, but these are potentially very large schemes, and really expert advice is required, whether it's from planning officers, planning consultants, or the legal profession, but there is significant scope for things to go well and significant scope for things to go horribly wrong. But for the time being, just to conclude, these permitted development rights for appropriate and relevant schemes represent a genuine alternative to going through the full planning permission process. That is ultimately one of the main reasons for them, in order to deliver development quickly or more quickly in the right locations. Whether they are too wide, of course, remains to be seen, and the effects will be seen for many years to come, no doubt. So that is my presentation. Thank you very much for listening. And if I could hand back to Suzanne.
Lovely, thank you so much, Christian, and thank you, Hannah, for your presentation earlier. Hannah, if you could reappear, we're going to do some questions. I'm just conscious we haven't got a lot of time for questions, but like I said earlier, the speakers have very kindly said that they will follow up with some of the questions that have been asked. Particularly, some have asked slightly more technical matters that I think need a bit of research than the off the top of the head answer, which I think, as we all know, is never the legal profession's favourite, the off the top of your head. So to start with, we've got a couple of kind of process-based questions. Is there a fee for the prior approval for the new ZAs, and how long do LPAs have to determine these new applications?
Don't know off the top of my head, if I'm honest. I don't know if there's a fee. I suspect there will be a fee, but I would have to look that up. Do you know? I don't know if Christian knows.
I don't know whether there'll be a fee. I suspect there would have to be changes to the development management procedure order, or the fee scale which sits alongside that. In terms of time period, that is an important point, because there are of course some permitted development rights for which a prior approval application is required, or a notification is required, and if a local authority doesn't respond within the required time period, then effectively one can crack on with the development. I did having had a look through, although I wasn't looking in detail at this point, I did have a scan to see whether there was a standout provision in there that said, if there's no decision within 8 weeks, then you can get on and do what you want. I didn't see it, and it's obviously I'd have to look into it further before I gave a definitive answer, but it seems to me that it would be inappropriate for schemes which could be very large residential developments, that a simple failure to respond could give rise to a situation where the development was in effect permitted.
Lovely, thank you. And then we've had some questions about exemptions as well. Are these changes, are the PD changes exempt in conservation areas and to listed buildings? Obviously, there's a lot of districts and authorities where a great many of their high streets and such like are within conservation areas, and I suppose this could be broadened out actually to all of the Article 2.3 land.
As far as I'm aware, they are. I'm sure they are, yes.
Yes, they are.
Yeah, I thought.
Lovely, thanks. And just picking up on what you were saying about the Christian, about the JR that's come in, that's being heard in October. We've had a question about two different questions, but they're sort of effectively a two-part question, I think. Does the legal challenge include Class A Part 20 PD rights that allow the creation of new flats above existing standalone blocks of flats that were adopted earlier in August? And do you want to answer that, and then I'll do the second part?
My understanding is, I've actually got their grounds. Just bear with me a moment. I've got their grounds just here. The challenge is against the two 2020 amendments, number 2 and number 3, and the use classes amendment 2020. My understanding is that it's all the recent changes, because what the applicant, what the claimant says is that the statutory instruments come into effect between 31st of August 2020 and 1st of September 2020. So I think there is an overlap in practical terms between what was permitted earlier, but the challenge is actually to those which we saw come into force last week.
That was my understanding as well.
Lovely, thank you. Just following on from that, if this JR is successful, what are the implications for anyone who's carried out development relying on these rights?
Yeah, it's an interesting point, and that is undoubtedly one of the reasons why it is being designated as a case to be heard very quickly, because of the uncertainty. Because of course, whilst the coming into force, or the decision to bring these into force, is under challenge, until such time as any challenge is successful, they are in force and they are the law. But to me, it seems no different to, say, for example, I had secured planning permission for the development of a large mixed-use scheme, and somebody wasn't very happy with that, and they decided to JR it. I could carry on with my development, confident that my legal team were going to dispose of this challenge successfully, and my planning permission would stand. But equally, you'd be taking a risk. So I don't see, aside from spending perhaps money on plans and fees, I don't see any risk in really. Well, the risk is the money you spend. I don't see any risk in making applications if someone really wants to get out the gates quickly on these, and be a pathfinder with one of the first prior approval applications. But I would have some hesitancy about implementing any schemes until such time as the legal challenge is resolved. Finally resolved.
Hannah, have you got anything you'd like to add to that?
I suppose if the legal challenge is being heard, is it the beginning of October, Christian?
Yeah.
A lot of these applications might not even be determined by that point, because even if you got it in for the 1st of September, you've still got. I can't see many of these applications being determined before that time period anyway. So at this stage, I don't think it's something that you would need to worry about until obviously that challenge has been heard in the High Court.
Lovely, thank you. I've got a whole list of other questions, but we will send them on to you, because I'm just conscious that it's 2 minutes to 11. So once again, if I can just thank the both of you for that presentation. I certainly found it interesting, and it's always much easier, I find, especially with PD, which is really quite complicated with all the many conditions, to have somebody who really knows what they're talking about explain it to you in what I would refer to as the simple words. So thank you once again. Thank you everybody for attending. Just a couple of final points. Next week, a copy of the video, the presentation, and further answered questions will be emailed to all of you. You can keep an eye on the RTPI website for more virtual opportunities. There's some really interesting stuff coming up. There's a webinar at the end of the month on health and well-being on the 30th of September. And then there's some stuff coming up about the reuse of historic buildings and a planning system fit for the 21st century, which I think is a particular hot topic at the moment, in mid-October. So if you go onto the RTPI website on the events page, they are all listed on there. We will send you all a feedback survey, which will be immediately launched following the session. It's really helpful if you can take the time to fill it in. It helps us to plan future sessions with what people are interested in, and kind of how you feel the webinars are going. Obviously, like Christian said earlier, this is a little bit the new normal for us doing these webinars. We've not done that many of them yet. So any feedback is always welcome, but preferably the nice stuff. Thanks. So and on that note, I think that's us wrapped up at 11 o'clock. Thank you very much.
Thank you.
Thank you.